Limited, Johnson against First Rand Bank Limited, Moto Novo Finance, and Wrench against First Rand Bank Limited, Moto Novo Finance.
I should begin by explaining why the court is handing down this judgment on a Friday afternoon rather than in the morning as we usually do. The court has been advised by the Financial Conduct Authority, the FCA, that the outcome of this appeal, whatever it may be, may affect the price of securities issued by companies involved in the car finance market, and the market will need time to digest the judgment and consider its implications. If the court were to issue the judgment during trading hours, there would be a risk of market disorder. The court has therefore obtained the views of all parties, including, of course, the individuals whose claims are before the court, on a suggestion that the judgment might be given after the market had closed for the weekend. No party has objected. So that is what the court is doing in order to avoid causing unnecessary disruption. The court has before it 3 cases brought by individuals who bought used cars on hire purchase. In its simplest form, this type of finance involves a finance company buying the car from the dealer and the customer paying the finance company the price of the car over a number of years in the form of monthly payments of capital and interest on a loan. The finance company hires the car to the customer during the period when the monthly payments are being made and transfers the ownership of the car to the customer at the end of that period. So these agreements normally involve 2 back-to-back agreements. The first is an agreement between the dealer and the finance company for the sale of the car. The main matter it deals with is the price which the finance company will pay the dealer. The other agreement is between the customer and the finance company, under which the car is hired to the customer and the customer undertakes to repay a credit. The amount of the credit will depend on the price that the finance company is paying the dealer for the car and the amount which the customer pays as a deposit. It will also depend on whether the customer is to become the owner of the car once he or she has repaid the credit, or is being given the option to buy it for an additional payment known as a balloon payment under a type of arrangement called a personal contract purchase, or PCP. Other matters dealt with in the agreement will include the interest rate and the period over which the credit is repayable. In order to understand the court's decision in these appeals, it's necessary to understand that these 2 agreements, the one between the customer and the finance company and the one between the finance company and the dealer, are dependent on each other, so as to form a 3-cornered arrangement. The dealer cannot sell the car unless the finance company buys it. The finance company will not buy it unless it has agreed a finance package with the customer, and the customer will not agree the finance package unless it's on terms which are satisfactory to him or her. Since the car dealer has a commercial interest in selling the car, it follows that the dealer also has a commercial interest in the successful conclusion of a finance package between the customer and the finance company. For the dealer, this is essentially a sale transaction from start to finish. The car dealer's commercial interest in the successful conclusion of the agreement between the customer and the finance company can affect its behavior in a number of ways. Depending on the terms which the finance company is willing to offer the customer and the customer's response, the dealer may have to adjust its own position or persuade the customer to adjust his or hers. For example, if, as in one of the cases before the court, the finance company is unwilling to advance a credit under the hire purchase agreement which is large enough to match the price the car dealer is asking for the car, the dealer may be able to arrange for the customer to take out a personal loan from the finance company in addition to the credit advanced under the hire purchase agreement so as to bridge the gap. To give another example, if the monthly payments demanded by the finance company are more than the customer is willing or able to pay, then the dealer will have to find a way of reducing the payments in order to achieve a sale. One solution may be to reduce the amount of the credit, for example, by agreeing that the customer will not become the owner of the car when the credit has been repaid, but will have to make a balloon payment at that point if she or she wants to buy it. In other words, getting the customer to take out a PCP package rather than hire purchase of the classic form. Another solution may be for the dealer to reduce the price of the car. Another may be for the dealer to offer the customer additional benefits, such as a warranty, so as to secure the customer's agreement. Or, as in one of the cases before the court, the dealer may have a discretion to reduce the interest paid by the customer, although doing so may affect the commission the dealer receives from the finance company, a practice which has since been prohibited by the FCA. Another solution may be for the dealer to interest the customer in a cheaper car. An alternative for the customer may be to buy a car from a different dealer offering a more competitive or affordable package. The important point to understand is that the car dealer has a commercial interest in the negotiations over the customer's finance package, which continues until the transaction has been entered into. The customer's contract is with the finance company, not the dealer. But the customer does not deal with the finance company directly. Instead, the car dealer acts as an intermediary, obtaining the customer's personal, employment and financial details and providing them to the finance company, obtaining an offer of credit from the finance company, seeing whether the terms are acceptable to the customer, and trying to resolve any difficulties that may arise. If an agreement is reached, the dealer then ensures that the documentation for the agreement between the customer and the finance company is properly completed. In undertaking all these tasks, the dealer does not act as the agent of the customer. It does not receive any remuneration from the customer. It does not give the customer any undertaking or assurance that it is putting its own commercial interests aside. It couldn't, because, as I've explained, it is pursuing its own commercial interests throughout the process. The dealer is usually paid a commission by the finance company. This may be disclosed in the documentation provided to the customer, or the documentation may simply disclose the commission of an unspecified amount may be paid, or it may say nothing about it. In these proceedings, 3 customers who acquired cars on hire purchase are seeking to recover from the finance companies the amount of the commission which the finance companies paid to the car dealers. Their claims are advanced on 3 grounds. First, it is argued that the finance companies bribed the dealers by paying them a commission, with the consequence under the law of bribery that the finance companies are liable to pay the customers an equivalent amount. Secondly, it's argued that the dealers owed the customers a fiduciary duty, that's to say that they owed a single-minded duty of loyalty to the customers and therefore were not permitted to have any personal interest in the conclusion of a hire purchase transaction. If that is right, it would follow that the dealer's acceptance of the commission was a breach of their fiduciary duty, and that the finance companies who paid the commission are liable to compensate the customers for dishonestly assisting the dealers to commit that breach of duty. Thirdly, it is argued in one of the cases, that brought by Mr. Johnson, that his relationship with the finance company was unfair, as that term is used in the Consumer Credit Act of 1974, and that the court should order the finance company to pay him damages. In the county court, the customer's claims were dismissed, either by the trial judge or on appeal, insofar as they were based on bribery or on a breach of a fiduciary duty. No final decision was reached on Mr. Johnson's claim of an unfair relationship. The cases then proceeded to the Court of Appeal, which held that all the customer's claims succeeded. In the cases where there was no disclosure that commission might be paid, the Court of Appeal held that the payment of the commission was a bribe. In the case where it had been disclosed that commission might be paid, but not the amount, the Court of Appeal held that the dealer had been under a fiduciary duty and that its acceptance of the commission was a breach of its fiduciary duty, as the customer had not given his or her fully informed consent. In Mr. Johnson's case, where it's argued that the relationship was unfair, that argument was also sustained. So all the customers were held to be entitled to recover amounts from the finance companies equivalent to the commission which the finance companies had paid to the dealers. The decision of the Court of Appeal came as a shock to the car finance industry, as it conflicted with the assumptions which had been made not only by the industry but also by the FCA as its regulator. The finance companies appealed to this court. The FCA was permitted to intervene, as were several other parties. The Treasury also sought to intervene, but their application was refused, as their arguments concerned the economic consequences of the Court of Appeal's decision. The Supreme Court is only concerned with the legal issues in the case. In the period since the Court of Appeal's decision, claims management firms have encouraged anyone who bought a car on hire purchase or with a PCP to sign up with them. And no doubt a great many people have done so under the impression that they had a valid claim. But it was too early to form any view as to whether a valid claim lay on the basis of the Court of Appeal's decision, as the decision was under appeal, and it was only once this court decided the appeal that it would become clear whether the Court of Appeal had decided the cases correctly or not. For the reasons set out in detail in a judgment published today, the Supreme Court allows the appeals brought by the finance companies. However, we uphold Mr. Johnson's claim that the relationship between him and the finance company was unfair, and we allow the appeal in his case only because the Court of Appeal made a number of mistakes in reaching its decision. Retaking the decision on a proper basis, we award him the amount of a commission plus interest. The other customers' claims are rejected. We reject the claims based on bribery on the basis that the payment of a commission was not a bribe. Under the civil law of bribery, as opposed to the criminal law, a bribe is a payment made to a fiduciary which creates a conflict with his duty of single-minded loyalty to the person on whose behalf he is acting. The law of bribery only applies to persons who owe a single-minded duty of loyalty and are therefore bound to have no personal interest in the matter that they are dealing with. In the present case, the car dealers plainly and properly had a personal interest in the dealings between the customers and the finance companies, as I have explained. they were motivated throughout by their interest in selling cars at a profit. It follows that they did not owe any fiduciary duty to the customers. Each party to the three-cornered arrangement, the customer, the dealer, and the finance company, was engaged at arm's length from the other participants in the pursuit of its own objectives. Neither the parties themselves nor any onlooker could reasonably think that any participant was doing anything other than considering its own interests. For the same reason, there can be no remedy against the finance company based on the theory that the car dealer acted in breach of a fiduciary duty in accepting the commission. It was not a fiduciary, that's to say, a person entirely committed to acting in another person's interests without any interest of his own. On the contrary, the car dealer was at all times pursuing its own commercial interest in achieving a sale of a car on profitable terms. In reaching the opposite conclusion, the Court of Appeal failed to understand that the dealer has a commercial interest in the arrangement between the customer and the finance company. The court mistakenly treated the dealer as acting solely in the interests of the customer once the customer had chosen a car and agreed a price. The Court of Appeal also attached significant weight to findings that the customers trusted the dealers and were in a somewhat vulnerable position. That was the wrong approach. A fiduciary duty of loyalty is not generated by feelings of trust or by vulnerability. It is not a form of consumer protection. It's generated by an undertaking to act entirely in another person's interests without regard to one's own. That was obviously not the position of the dealers, interested as they were throughout in achieving sales. The question of an unfair relationship raises different questions. The statutory test of unfairness under the Consumer Credit Act allows courts to take account of a very broad range of factors and is highly fact-sensitive. The court considers that the following factors will normally be relevant: the size of the commission relative to the charge for credit, the nature of the commission, because, for example, a discretionary commission may create incentives to charge a higher interest rate, the characteristics of the consumer, the extent and manner of disclosure of the commission, and compliance with the regulatory rules. That is not an exhaustive list. The fact that there has been no disclosure of a commission or only partial disclosure will not necessarily make the relationship between the customer and the finance company unfair. It is simply a factor to be taken into account in the overall balancing exercise. There are three relevant factors on the facts of Mr. Johnson's case. First, the size of the commission paid by the finance company to the dealer. It amounted to 55% of the total charge for credit. The fact that the undisclosed commission was so high is a powerful indication that the relationship between Mr. Johnson and the finance company was unfair. Secondly, it is highly material that the documents provided to Mr. Johnson did not disclose the existence of a commercial tie between the finance company and the dealer, under which the finance company was given a right of first refusal of customers referred by the dealer. Instead, the documents created and were intended to create the completely false impression that the dealer was offering products from a selected panel of lenders and recommending the finance product that best met Mr. Johnson's individual requirements. Thirdly, on the other side of the scales is Mr. Johnson's failure to read any of the documents provided by the dealer. However, Mr. Johnson was commercially unsophisticated, and the court questions the extent to which a finance company could reasonably expect a customer to have read and understood the detail of such documents, particularly when no prominence was given to the relevant statements. For these reasons, the court holds that the relationship between Mr. Johnson and the finance company was unfair, and that the finance company should pay the amount of the commission to Mr. Johnson with interest at a commercial rate from the date of the agreement. For the reasons I've explained, the other customers' claims are rejected. The court will adjourn.